Okay. Good evening and welcome to our last panel about the protection of the rule of law in the European Union. First of all, I have to say that Mr. Judge Eugene Regan can be here with us today. So I will have two hats, and I will be the moderator and the panelist at the same time. So like this, we can cover all the subject that we think we would like to cover. Let me introduce myself. I am Rosario Silva. I am from Spain, and I have been for 18 years the Spanish judge at the European Court of Justice and the vice president of this institution until October 2021. In my right, I have Judge Sinisa Rodin, born in Zagreb, in Croatia. He obtained his law degree from the University of Zagreb and a Master of Law from the University of Michigan, Doctor of Law from the University of Zagreb, and Fulbright Fellow and visiting scholar at Harvard University, Professor of EU Law at Zagreb University, Chair Jean Monnet, and visiting professor at Cornell Law School. And he is the first Croatian judge to be appointed to the Court of Justice, and he has served as judge at the court since the 4th of July 2013. And in my left is Lucia Serena Rossi, born in Bologna, Italy. She obtained a degree in law and a doctorate in European law at the University of Bologna. She is a professor of EU law at this University of Bologna, and she has at the same time taught public international law and private international law at the same university. She's a visiting professor, or she was a visiting professor at Robert Schumann Université Strasbourg and Paris 1 Panthéon-Sorbonne at the King's College in London. She was appointed as a judge at the European Court of Justice in October 2018. With that, I'm going to give the floor to Judge Sinisa Rodin to talk a little bit about the values of the European Union.
Yes, thank you, Rosario, very much. When we talk about the rule of law, we don't exactly know what we are talking about because understanding of the rule of law is so different from one legal culture to another, and even within the same legal culture, there is no consensus on the actual contents of the rule of law. If we go to the very origins of the phrase, the rule of law, we will find the famous writing of John Adams, who became the second president of the United States, and this statement was published in his letters that he was writing before adoption of the Constitution of the Commonwealth of Massachusetts, where he said something like, I'm paraphrasing, I don't know if these are the exact words, but he used the phrase government of laws and not of men. So that was the crucial idea that a Commonwealth should be governed by law and not by whim of an emperor or by whim of political branch only. From there on, the rule of law has developed into an understanding that each government in constitutional liberal democracy should be checked by the judicial branch. And therefrom originates the system of checks and balances, the idea of checks and balances, but also the idea of independent judiciary, which is able in practice to check, impose the checks on the executive and legislative branch. If you look at the so-called rule of law jurisprudence of the Court of Justice of the European Union, you will see that now within an ever-increasing volume of cases that the court has decided, most of these cases refer to independence of the judiciary. So, in fact, when we talk about protection, judicial protection of the rule of law in the European Union, we are by and large talking about independence of the judiciary and the role of the Court of Justice in this process. I'm not saying that there are not other cases which are relevant for the rule of law, like protection of independence of other institutions, freedom of speech. We have heard the panel earlier today about the freedom of speech. All these things do come within the heading of the rule of law, but that's not, I would say, the main. It doesn't come within this main volume of what the Court of Justice is doing. Now, when we talk about independence of the judiciary, we most often what we most often have in mind is independence and impartiality of the judiciary. And I'm not going to talk about that. Other colleagues will do. I want to talk about one different thing, which also can be found in cases of the Court of Justice, just to a much smaller extent, and that is the idea of judicial neutrality. And neutrality, at the outset, I have to say, is something different than independence and impartiality. So I would suggest that judicial neutrality, unlike independence and impartiality, can exist only within one single tradition. And in the case of the European Union, it is the tradition which is described by the values which are enshrined in Article 2 of the Treaty on European Union. And these values, by and large, correspond to values of any other liberal constitutional order. And just to remind you of Article 2 of the Treaty of the European Union, it says respect for human dignity, freedom, democracy, equality, the rule of law, respect of human rights, respect for rights of people belonging to minorities. So these are the values that we are talking about when we talk about judicial neutrality. Well, this said, I make a theoretical but also practical distinction between neutrality of a constitution and neutrality under the constitution. And within this context, within this difference, I want to suggest that neutrality under the constitution can exist only once neutrality of the constitution does not exist. So we must not, as judges, be neutral in constitutional sense in order to be neutral under the constitution. Why? Because no constitutional order, including the order of the EU, is neutral. It is not neutral, it has its values, and these values need to be protected by the judiciary. Otherwise, it would be a suicidal strategy if courts, the highest courts within one constitutional order, would not uphold these values. So EU law, European Union is not a neutral project, and Article 2 of the Treaty of the European Union is also not neutral. It lays down the values which stand for certain, well, constitutional choices. Well, another thought that I have in this context is that neutrality under the Treaty of European Union, so neutrality under the European Union Constitution, allows everyone to pursue his or her idea of good life as long as it does not harm the others. That's the basic liberal democratic assumption. And this is the root of the claim, that the Court of Justice, as the highest court of the EU, should not only be independent and impartial, but also neutral within the tradition of the European Union enshrined in Article 2. But now, when we talk about tradition, what is this tradition when we talk about the European Union? Well, I have tried to outline some minimal contents of European legal and political tradition. So first, it is a supranational, or we can say quasi-federal structure, horizontal and vertical separation of powers, independent judicial review, including checks and balances, respect for fundamental rights, but also, not less importantly, some inherent counter-majoritarianism and protection of a weaker side. When I say protection of a weaker side, you can see it in many areas of EU law. You can see it in competition rules. You can see it in consumer protection. You can see it in privacy protection. You can see it in equality guarantees. So it goes whenever EU law applies to individuals and protect them against some, well, external legal, political, or economic power. And of course, in recent case law, the Court of Justice has also confirmed that all these values mentioned in Article 2 and all these minimum contents of European tradition actually is binding also to the member states. It's not only binding for the institutions of the European Union, but also for the member states. So at the outset, I have mentioned that independence and impartiality are not tradition sensitive. Let me just explain it a little bit. You can imagine legal systems that are born out of a completely different tradition than the one we exist in. And judges within that tradition can be impartial and can be independent. But for us, participants of another tradition, they will never be neutral. And the other way around, us and our legal decisions will never be understood as neutral if you look from the outside of this tradition. You can call it cultural relativism, but that's the way how it is, and this is the source of many, I would say, ideological misunderstandings within the European Union, but also when we talk about, well, relationship of EU and some other cultural systems which are external to it. So independence and impartiality are not tradition sensitive, but I claim judicial neutrality is. Also, another distinction between independence, impartiality on one side and neutrality on the other is that the former answers the question how courts operate independently, impartially, but the latter answers the question to what end courts operate. So what is the final end game of the judicial activity? So I'm aware of a scarcity of time. So just to bring this point to some concrete end, I would like to just show you on one example what does Court of Justice say about judicial neutrality, because this is not really something that is mentioned quite often. So the definition starts from independence and impartiality. But then, once independence and impartiality are achieved, the court uses a formula sometimes which says that the guarantees of independence and impartiality require rules that are such as to dispel any reasonable doubt in the minds of individuals as to imperviousness of that body to external factors and its neutrality with respect of the interests before it. So first, it is an appearance of judicial neutrality. It's not something concrete, objective that can be clearly defined. So we have to create appearance of neutrality. And second remark, neutrality is almost a mechanical function of independence and impartiality. So it is assumed that once objectively independence and impartiality are achieved, voila, here comes neutrality, and that is neutral. But with this caveat in mind, this only functions within the tradition of the European Union, because it may be different if you look out from perspective of other traditions. The question for the Court of Justice of the European Union, and also for all highest courts in any jurisdiction, is it possible or not to operate regardless of the tradition which the court makes part of? And my answer to this question, and this is my last thought, that it is not possible, and that the court should not try to operate outside the tradition. Instead, the Court of Justice, but also this, as I said, refers to all other highest courts, is supposed to cultivate and defend the tradition which is enshrined in its constitutional order, in concreto in Article 2 of the Treaty of the European Union, in order to make this constitutional order persevere and well, further develop. And I will stop at this point. Thank you very much.
Thank you, Sinisa.
Do you have some water?
No, water. No, I think you must go to
Outside,
find it.
yeah.
I'm going to give the floor to Lucia Rossi.
Thank you very much, and thank you for inviting me in this very interesting conference. I'll try to make to explain why the Court of Justice tackled these issues of the rule of law, how it tackled it, and what are the perspectives and all the problems involved in this case law of the Court of Justice. I start admitting that the Court of Justice has been very creative in this case law. Why? Because why was it necessary to be creative? Because there was a total inertia of the other EU institutions. The Council of Ministers never pursued seriously Article 7. There was a tentative, but Article 7 is TU is the atomic bomb that cannot be used and is not deterrent, as we see. The Commission was hesitating a lot before promoting infringement procedures. So it was up to the court to use all the tools available, and the court really used all of them: preliminary rulings, infringement action, orders, interim measures. Mrs. Silva is very known for as judge rapporteur, reporting judge of the first ones. And all the principles that the court could use were used in a creative way. Why? Because it was not evident that the Court of Justice had the competence in deciding what is the rule of law. It was neither clear whether the EU had such a competence, because before the judgments of our court, many scholars affirm that Article 2 give no competence to the EU. It's not a competence, it's just a list of values. But these values enshrined in Article 2 can be considered the fondative values of the European Union. Actually, there was an evolution. At the time of the European Economic Community, nobody spoke of values. Of course, it was a market organization, mainly a market organization. And then the fundamental rights with the Maastricht Treaty entered into the system. The individual rights as well were very much developed by the Court of Justice. But it is with the Treaty of Lisbon that the Union make a qualitative jump, a qualitative step. The Union now is really founded on the values of Article 2. We have the Charter of Fundamental Rights, as to the individual's rights are concerned. And I must underline that, as Sinisa Rodin said, it is true, at the moment only the issue of the judicial independence has come to the attention to the court, but it could expand. Of course, the court does not decide itself what to say. I mean, in order to give answers, we need questions. And at the moment, the questions we received relates to the judicial independence. This, which is one of the many dimensions of the rule of law. Why judicial independence? There is a reason, and the reason is clear if we read some case law. For instance, the Land Essen case, and in this case of 9 July 2020, the court explained that the judicial independence is relevant for the Court of Justice of the EU law under three different dimensions. The first is a dimension related to Article 2 and 19, that is a systemic threat to the EU law. Article 2 is the provision of the fondative value. Article 19 is a provision that also was read by the Court of Justice in a creative way starting from Juge Portugais, the Portuguese judge's case of 2018. Because Article 19 TEU only says that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. That's it. But first of all, in Juge Portugais, the court said that the independence of judicial is an essential element of the due process, that Article 19 has direct effect and oblige the member states. So let's come back to Land Essen, to this judgment in which the court said we have different dimensions of the independence. The first is the systemic one, 2 and 19. That is a very serious situation where the fundamental rights as such are at the stake, the fundamental principles are at the stake, where a state cannot more assume in general, cannot more guarantee in general judicial independence. This is the most serious case. Then we have a second dimension of independence, judicial independence, that is the individual rights to a due process. And these are relevant for EU law under Article 47 of the Charter, which also embodied all of the case law of the Strasbourg Court on Article 6. So this is the individual dimension. Differently from the systemic dimension, this individual violation can occur in states that perfectly guarantee the rule of law. We can have a state where the rule of law is at the stake, where judicial independence is under threat, but in some particular case, Article 47 of the Charter is guaranteed because that single judge is, a good judge. There is no violation. And the other way around, we can have violation of Article 47 in states where 47 of the Charter, of course, in states where the rule of law is not under threat. But there is the third and obvious dimension that justifies, the monitoring of the Court of Justice what happens in the states, is this the dimension of Article 267 TFU. That is, independence is a basic feature, necessary feature, in order to allow some jurisdiction, the jurisdiction of the member states, to refer to the Court of Justice in preliminary rulings. So you see, there are different dimensions. This third dimension, for instance, we have this case Banco Santander. There was no systemic menace. There was no single individual case of not lack of independence of judiciary, but it was a judiciary designed in a certain way that cannot be considered independent because aborigine, of course. So it cannot refer to the Court of Justice. So that was the framework, the theoretical framework from which the Court of Justice started. From a more substantial standpoint, I already mentioned the Portuguese judge's case. That was the start, politically speaking, was a very small case, was not a highly politically sensitive case. It was just the pension of the Portuguese judges that had been cut in order to respect the austerity imposed by the EU system and the EU aids, financial aids that were given to the Portugal. But from this obiter dictum, it was an obiter dictum in Portuguese judges, the Court of Justice was capable to build a theory on the systemic threat. Another judgment is Repubblica, in which the Court of Justice underlined that the European Union is founded on the values of Article 2, and for the first time the Court said that those values are a condition for the enjoyment of all the rights deriving from the application of the treaty. Then the Court added something new, that is that in order to become a member state of the European Union, you must comply with the Copenhagen criteria. Rule of law is one of them. Probably is the most important of them. So the Court said, if you want to continue to be a member state, you are a member state, of course. You cannot be, expelled. This is not possible under the EU treaties. But if you want to enjoy of the rights that the EU system, the EU law and the EU system gives you the state, you cannot go back, you cannot step back in the protection of fundamental rights. And this is a condition. The fact that this is a condition allowed then the Court, on this theoretical premise, to condemn an infringement for the payments and to say that one member state that had violated Article 2 can be prevented to use, to be financed with the EU funds. So you see very concrete implication of this principle that the member states cannot step back in the protection of rule of law from the moment of the accession. The usual question at this point is, but is this principle applicable only to the new member states? No, it is applicable to all the member states, even the founding member states. Here we don't speak of exception, but the moment is the Lisbon Treaty. And as the Lisbon Treaty provides something new that was not existing at the moment of the foundation of the EU, these fundative values are the same for all the member states, not only for the new member states. then let's say the application of this theoretical framework that has made the Court of Justice so far. There are so many judgments that I can't speak of all of them. I just will very briefly resume something about the Polish cases and the Romanian cases, which are newer but even more interesting, in my opinion, from a theoretical point of view. Well, the situation in Poland of the judiciary was very critical, and the first judgment, Commission versus Poland, ascertained that there was a violation of Article 47 of the Charter. It was anticipating pensioning of the judges, but not of all the judges. There was a discretionary power of the executive to say you go to a pension and you can remain. So that was the real threat to the rule of law. And then we have this order 61918, where the court add some more elements, because the court explained that this lack of independence of the judiciary can be dangerous for individuals that cannot rely on a good judicial system, but also for the EU law. And behind this idea, there is the principle of equality of the member states. All the states are equal before the law. This is written in Article 40 EU. And if a member state has no effective independent judicial system, it cannot ensure the application of EU law to the national citizen and to the other citizens of the Union related with that state. The problem was at a certain moment with the reference to the appointment of the judiciary disciplinary chamber, in the case AK. The problem was, and in Miasto Woolwich as well, the problem was that is the Court of Justice able to define exactly what a national way of organizing the judiciary is or not good? Well, the court was quite prudent, creative but prudent, and said, after all, what we can do is just to give you a framework, give you a list of what in general should be respected. What are the necessary elements for the independence of the judge? And then, that was the idea, it belongs to the national judge to ascertain whether or not its own legal order respects this principle. That was the idea. At the beginning, the Court of Justice was very criticized by a part of the doctrine, saying, you charge the poor national judge of such a burden. But that was the only thing that we can do, because there is no harmonization of the organization of the judicial system. It's a question of sovereignty, it's a question of competence. So what we can do, and we did, is to say this element are necessary. And there can be, a different proportion, a different way to organize those elements. And then it belongs to the national judge. But we received so many requests of preliminary rulings by the Polish and Romanian judge that I think this show that it was a good idea, because there are the national judges that can detect if there is really or not a problem, if they feel that their independence is menaced. After AK and Miasto, the Court of Justice went on and with different aspects of the judicial system of Poland, and found a violation, different violation of different elements, and until there was an infringement procedure And in 2022, there was an order imposing a fine of 1 million per day to Poland. I also want to quote the VB Procuratura Reionova case, because there is a very important passage I want to mention, I want to read. Article 2 TU is not a mere statement of policy guidelines or intention, but contains values which, as has been set out in this judgment, in other part, are an integral part of the very identity of the European Union. As a common legal order, values which are given concrete expression in principle comprising legally binding obligation for the member state. This is a resume of what passed from Portuguese judges to VB. This short passage resumes very well the importance of Article 2. I mean, Article 2 is not a decoration, is not an ornament, is a provision that express the very identity of the European Union. And something like that has been stressed in the two plenary judgments about the funds Poland and Hungary made an annulment request and of the regulation on EU funds, and the Court of Justice rejected these two requests, and allowing this way the disbursement of EU funds to be suspended. And also in this case, the court stressed that these values of Article 2 define the very identity of the European Union as a common legal order. And adds, thus the European Union must be able to defend those values. Those values are also, there is no time to speak, but I was just to mention, I also mentioned in the framework decision of European arrest warrant, because the respect of those values is a precondition of the mutual recognition. It is possible to surrender in European arrest, under European arrest warrant a person. Why? Because there is a mutual trust among the member states. One state of the Union can trust on another member state to have an equivalent set of values, an equivalent guarantee of fundamental rights. That's why we can quickly surrender without another exam. So this is this principle that values are not only an expression of the identity, not only the consequence of the equality of member states before the law, but also they are the precondition for the mutual recognition. They are a precondition for enjoying the rights. You see, there are many different facets of these principles of Article 2 that are added more and more by the Court of Justice and contribute to give a clear picture of the evolution in a constitutional sense of the European Union. As far as the Romanian case, before concluding, we had the three important judgments, Associația, Eurobox, and RS. These are different cases. Here, the problem is, quite a muscular relation with the Romanian Constitutional Court. That at a certain moment seems to refuse the idea that all the judges of Romania can raise a preliminary request to the Court of Justice. Only the Constitutional Court would be able to say whether a national provision is compatible or not with EU law, and the Constitutional Court say, I'm the only one able to say that. I say, yes, in this case it is compatible. So you see, it's a problem. And then also the fact that there are disciplinary procedures against judges referring to the Court of Justice. So and I'm Italian. I say that this case law of the Romanian court remembers me what the Italian Constitutional Court said in 1973. So all these problems had already solved by the other Constitutional Court. So we just hope that as Romania is quite a new member state, maybe is just the beginning, not really the beginning, because it's 20 years ago, almost not 20, but something like that. Well, these are other interesting judgments about the rule of law as the ground of I don't want to say crisis, but I mean there are sensitive issues that some states perceive as related to their exclusive sovereignty. But they don't realize that the other member states already surrendered, already accepted that these are shared values, that there is a common surveillance of the respect of these values. To conclude, I just want to remind that this debate of the rule of law in the EU started as something like very academic, very abstract, now becomes more and more important with very sensitive constitutional implication, and it is really the ground for developing new constitutional principles in the EU. Thank you.
Thank you, Lucia. Then, for finishing this panel, I would like to talk a little bit more about the judicial independence. The Charter, in the second paragraph of its Article 47, explicitly provides individuals with the fundamental right to a fair trial before an independent and impartial tribunal previously established by the law, whenever they're relying on rights or freedoms guaranteed by EU law or are the subject of proceedings constituting the implementation of EU law. Over the last 5 years, as Lucia has already said, since this judgment of 27 February 2018, Asociação Sindical dos Juízes Portugueses, the European Court of Justice, taking into account the problems raised in some member states related to the rule of law, has defined the independence of a court and the different elements of this independence. The ruling of the Court of Justice mainly originate from cases brought by national judges using the preliminary ruling procedure. But infringement actions have also been brought by the Commission targeting the national legislative provision affecting the status of the judges. I am going to analyze some aspects of this judicial independence that have been controlled by the court. First, the requirement of judicial independence forms part of the essence of the fundamental right to a fair trial, a right which is of cardinal importance as a guarantee that all the rights which individuals derive from EU law will be protected and that the values common for member states set out in Article 2, as Lucia and Sinisa have already said, in particular, the value of the rule of law will be safeguarded. The guarantee of independence, which is inherent to the task of adjudication, is required not only in the EU level as regards the judges of the Union or the Advocate General of the Court of Justice, but also at the level of the member state as regards as other national courts. The Court of Justice has ruled that Article 19 of the EU, interpreted on the light of Article 47 of the Charter, imposes on member states a clear and precise obligation as to the result to be achieved that is not subject to any condition as regards the independence which must characterize the court's call upon to interpret and apply the EU law. Another aspect that the court has analyzed is the definition of independence of a court, using two aspects. The first, which is external in nature, requires that the court concerned exercise its function wholly autonomously without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from any source whatsoever, thus being protected against external intervention of pressure liable to impair the independent judgment of its members and to influence their decisions. The second aspect, which is internal in nature, is linked to impartiality and seeks to ensure that an equal distance is maintained from the parties to the proceedings and their respective interests with regard to the subject matter on the proceedings. This aspect requires objectivity, as Sinisa Rodin said before, and the absence of any interest of the outcome of proceedings apart from the strict application of the rule of law. To ensure the independence and impartiality of the judges, the court requires rules that are such as to display any reasonable doubt in the minds of individuals as to the impermeability of the body in question to external factors and its neutrality with respect to the interest before it. The rules applicable to the status of judges and the performance of their duties must define in particular the composition of the body and the appointment, length of service, and grounds for abstention, rejection, or dismissal of the members. Another aspect that the court has analyzed is the principle of irremovability. That requires in particular that judges may remain in their post provided that they have not reached the obligatory retirement age or until the expiry of their mandate, where that mandate is for a fixed term. While it is not an absolute value, there can be no exception to that principle unless they are warranted by legitimate and compelling grounds subject to the principle of proportionality. Thus, it's widely accepted that a judge may be dismissed if they are deemed unfit for the purpose of carrying out their duties on account of incapacity or a serious breach of their obligation, provided that appropriate procedure is followed. The requirement of independence also means that the disciplinary regime governing those who have the task of adjudicating in a dispute must display the necessary guarantees in order to prevent any risk of it being used as a system of political control of the content of the judicial decisions. Rules which define in particular both conducts amounting to disciplinary offenses and the penalties actually applicable, which provide for the involvement of an independent body in accordance with a procedure which fully safeguards the right of the defense, and which lay down the possibility of bringing legal proceedings challenging the disciplinary body's decisions constitute a set of guarantees that are essential for safeguarding the independence of the judiciary. The court has specifically analyzed the question of the disciplinary proceedings against a judge for making a preliminary ruling. Being the preliminary ruling the keystone of the judicial system established by the treaties, and having the national courts the widest discretion in referring matters to the court if they consider that a case pending before them raises questions involving the interpretation of EU law or the consideration or the validity, which are necessary to the resolution of the case before them, no national rule can prevent a national court from exercising that discretion. Furthermore, the court has examined, in relation with the judges' disciplinary regime, the question of their personal and disciplinary liability. In case C-799-19, Commission versus Poland, the court starts saying that the disciplinary regime applicable to the judges fall within the organization of justice. However, in exercising that competence, the member states must comply with EU law. In that context, the safeguard of the independence cannot have the effect of totally excluding the possibility that the disciplinary liability of a judge may, in certain way, exceptional cases, be triggered as a result of judicial decisions adopted by the judge, as, for example, when the judge acts violating deliberately and in bad faith, or as a result of a particularly serious and gross negligence, the national law, or acting arbitrarily or denying justice when they are called upon to rule in disputes which are brought before them by individuals. The court declares that it's essential that the fact that a judicial decision contains a possible error in the interpretation and application of national courts, the EU law or the national law, or in a settlement of the facts and appraisal of the evidence, cannot in itself trigger the disciplinary liability of the judge concerned. The last aspect of the judicial independence that I want to refer is the rules that govern the appointment of judges. In that regard, the court has said that although the organization of justice in the member states fall within the competence of those member states, the fact remains that exercising that competence, the member states are required to comply with that obligation deriving from EU law. It is therefore necessary that the substantive condition and procedural rules governing the adoption of decisions to appoint judges are such that they cannot give rise to reasonable doubts in the mind of individuals as to the impermeability of the judges concerned to external factors and as to their neutrality with respect to the interest before them once they have been appointed. In multiple decisions, the court has had the opportunity to analyze the compatibility with union law of the national proceedings to appoint judges and has analyzed different elements that are present in the appointment of judges in some member states, such as the appointment by the President of the Republic or the intervention of a body that is in charge of the organization of the judiciary. In regard to the intervention of the President of the Republic, the court has admitted, since the judgment of 19 November 2019, the one that Lucia mentioned before, that the mere fact that the judges are appointed by the President of the Republic does not give rise to a relationship of subordination of the former to the latter, or doubts as the former's impartiality. If once appointed, they are free from influence or pressure when carrying out their role. However, it's still necessary to ensure that the substantive condition and detailed procedural rules governing the adoption of appointment decisions are such that they cannot give rise to reasonable doubts in the mind of individuals as to the impermeability of the judges concerned to external factors as to their neutrality. In regard to the intervention of a body that is in charge of the organization of the judiciary, the court analyzed the procedure for the appointment of the judges of the Supreme Court of Poland, and specifically the disciplinary chamber. In the judgment AK, that he said that the participation of such a body in the context of a process for appointment of judges may, in principle, be such as to contribute to making that process more objective. However, that is only the case provided, inter alia, that the body is sufficiently independent of the legislative and executive powers and of the authority to which it is required to deliver an appointment proposal to. In conclusion, analyzing all the jurisprudence of the Court of Justice about judiciary independence, we can come to 4 fundamental ideas. The first is that the Court has analyzed the respect of the independence of the judges on tribunals in relation with Article 19, TU, and 47 of the Charter, and considers that every member state must ensure that the body which, as court or tribunals within the meaning of EU law, comes within its judicial system in the field covered by Union law, meets the requirement of effective judicial protection. The second is that the Court has relied that the requirement of judicial independence forms part of the essence of the fundamental right to a fair trial, a right which is of the cardinal importance as a guarantee that all the rights which individuals derive from EU law will be protected and the values common to the member states set out in Article 2 TEU, in particular the value of the rule of law, will be safeguarded. The third is the recognition that the organization of justice in the member states falls within the competence of those member states, and there is not a unique constitutional model that has to be respected. Nevertheless, when exercising that competence, the member states are required to comply with their obligation deriving from EU law. And 4, the necessity to protect judges from external intervention or pressure liable to jeopardize their independence. In that sense, it's necessary to preclude not only any direct influence in form of instructions, but also types of influence which are more indirect and which are liable to have an effect on the decision of the judges concerned. In that regard, it is essential that the judges are seen as impartial and independent so that the trust in justice, which in a democratic society must be inspired in all subjects of law, is not compromised. With that, I think we have a panorama of what the Court of Justice has said about judicial independence, complete with the values that are in Article 2 and the guarantees that the Union law has to make the member state respect these values. And before giving you the possibility of saying or making some questions, I would like to say something that Lucia said before. The court cannot, and it was criticized at the beginning, because when we receive a lot of preliminary rulings from Polish judges, we didn't say this legislation, those measures adopted by the authorities of Poland are contrary to Union law. But we didn't did that because we couldn't. We were in a preliminary ruling procedure. In these cases, only the judge make the question, the court answers the question, and is for the national judge to resolve the case in the basis of the interpretation given by the court. But saying that this is compatible or incompatible with EU law is not a matter for the court, but it's a matter for the national court. When a case for infringement was brought by the first time by the Commission against Poland, there, yes, the court said this is contrary to EU law. But because it's another different procedure, it is only by an infringement procedure that the court can say that a national law is contrary to EU law. So, is there any question? Thank you. Somebody want to add something? Well,
Should I have mic?
yeah.
Microphone.
I think
Maybe
there is not
maybe
that-
you
but
can you can come
you
over.
You can
Yeah.
use one. We have so many people. No problem.
Actually, yes. Thank you, Madam Chair. Actually, you summarized very well that you made a panorama here. Your presentations complemented very well each other and shed a light on the state of the rule of law within the European Union. And I must say that I don't blame us who are here, but I'm a little bit astonished. We have 3 judges from the EU Court of Justice, and we are a little bit more of audience. So you would have deserved much more, but we have got very much of your presentations and your analysis. So as not to take too much of the time, I would like to make just one comment or tell a story. It might be not known to all of you concerning the rule of law, not in the EU, but concerning a case linked to Iceland. So I think no, actually the Strasbourg court, because
I know.
yeah. So at least we, from a Nordic country, we are very convinced that we are defending the rule of law, and we are the best pupils in the class. And we have also thought that Iceland will match to these definitions too. But then on Iceland, they had just 2 courts, the district court and the Supreme Court, and then they decided to found a new instance in between, Court of Appeal. And they hired, I think, 14 judges. There was a board who made the qualification, and they put the applicants in a ranking order, 14 applicants. But then the Minister of Justice, who was responsible for making a proposal to the Parliament and then to the President of the Republic, she took 4 other candidates who outside the list of the most meritorious candidates and put them there. And the case ended into European Court of Human Rights because of one petty criminal case where someone was convicted in that court, and he claimed that this was not a lawful court at all, because the appointments were violating the rule of law in a flagrant way. And the case ended up to the Grand Chamber of the court, and they said that so it had happened, and the story ends there. But I happen to know that the then Minister of Justice is not working in this business any longer. But thank you once again for your presentations, and to the court as a whole for taking such an active role in defending the rule of law. I would say that my example concerning Iceland reminds us all that we have to be very agile and be able to see the signs when the rule of law will be eroded. Thanks so much.
Thank you. Thank you. Yes.
Shall I come over there?
Please. Yeah, I mean, microphone is over there. Yeah.
Sorry. Okay, sure. So I will be.
Okay, I will be very fast. So first of all, I have an explanation of this lack of people, because there was the arrow restrooms, not CLA. So that's why we didn't know where was the room. So that's the reason. So it was a treasure hunting here. So that's probably the explanation, Carrie. Second of all, so we had a beautiful scenario and panorama about the function of justice and ECJ and so forth. But I would like to ask you, what is, in your opinion, the function of the independent authority, the administrative authority? So do they have just a technical function, or we can forecast as well a more less technical intervention for what you were saying, Sinisa, about neutrality, about protection of human rights and so forth. Human rights, you understand what I mean? Yeah, so the function of an independent authority. And I'm making reference especially to EBA, so European Banking Authority, and the ESMA, European Security and Market Authority. Yeah, thank you.
There are some interest case, Corneli, you probably know, under pending cases. Yes, I asked to answer because I have to speak of that in the 4th of September in Frankfurt, the European Central Bank, and then to Italian national. No. I mean, this is a new problem because the public authority, in the sense of public administration, since Costanzo, is clear that they have to give direct effect, if possible, or interpret in conformity, if it is the reverse. But anyway, they are part of the state, and as a part of the state, they are due to apply correctly the EU and disapply national provision if it is necessary. This is very, very, clear. The problem you raise is in a certain sense a new problem, because now we have a lot of agencies, a lot of something in the banking union, double hats. That's the problem of the banking authority, because they have to apply the EU law as well as the national law. For the banking under supervision, European supervision. These are, and there are some pending cases. In my opinion, they are still administrative authorities, not judicial ones. This doesn't mean that they are free not to apply the EU law, but they are always, it is always the Costanzo logic, and I think that with this theoretical framework, we can cover all the situation. There are now some debates about the fact that, for example, the interpretation of in conformity in the European Banking Union, the limit of consistent interpretation, that is contra legem or not, must apply also to the, in the banking union, to the ECB, or not, to the central, to the national bank competent authorities. I think that we have to have some concrete cases in order to answer. Usually the Court of Justice has an inductive method, not deductive. That is, when there is a case, the court starts reflecting to the new problem. If the court is able to find at the first time, since the first time, a sound framework, then it can be applied. But the court is also capable to correct itself. So, I say Costanzo, but probably when we have a case like Corneli, which is pending, we can say more, something clearer. I'm sorry I can't give you a definite answer.
But I think there are two different things. One is that all these bodies, administrative bodies, have the obligation of apply union law. As Lucia said, is Constanzo. And I was in Constanzo as abogado del Estado, represent the agent of Spain. And I can tell you something that nobody knows, is that there was two questions in this case. The first was the direct effect of provision of union law for the municipality of Milano. And the other was just the interpretation of the directive about public procurement. So, because there was a joint venture between Italian company, Constanzo, and a Spanish one, Uralita. No, Dragados. Uralita was another one, Dragados. I was there to defend the position of this enterprise or this company, and I was only going to talk in the hearing about the procurement directive. So when I arrived in the, you know that always at the court we have this preliminary meeting with the lawyers and the agents, and the president at that time said, we know very well what we are going to say about the directive, so don't talk about that. You have only to talk about the direct effect. And I say, I'm Rosario, you have never prepared this because I was not prepared for that. And because I was not the first one to talk, I could just think about it. And when I start talking, I was the only one in the room that defend the direct effect. Even the commission didn't do it. It was unbelievable, but then the court said what it has to say, that they had this direct effect. So I think this question is already solved, and we have this. It was a case when I was judge rapporteur. It was 2020, something like that, an Irish case about the authority is, we repeat, Constanzo. It was an authority that was in charge of the principle of equality in all the matters, not only in labor cases, but in everywhere. And the question was, this body was obliged to apply the union law? And we said yes, and we remember Constanzo. So that is one thing. Another thing is, are they obliged to be independent in the way the court has said independent for a judicial body? And I said, no, it's not the same. If they don't respect this judicial the independence, they cannot make a preliminary ruling. That's clear. That is Santander. But they can do their job, but never ask for a preliminary ruling at the court. So I think we have to make this difference, but we will see. Something more? Okay, so thank you very much for coming. We were in a petit comité.